Good day, Crime Talk aficionados. My name is Scott Reisch, and this is Crime Talk, the most fact-driven, unbiased true crime channel. First on the docket, the South Dakota Attorney General has charges filed against him. Second, did the prosecutors in Minneapolis cross the line, or are they just playing a little hardball? 3, you must have a license to perform surgery, even on animals. 4th, another school case. Can you guess for what? 5th, case closed with remains found. Unusual circumstances, though, because the suspect has already been found guilty. And finally, our dumb criminal contestant of the day. Let's talk about it. Good day, Crime Talk aficionados. This is Crime Talk. My name is Scott Reisch. Thanks for watching. If you haven't done so already, we'd ask that you please hit that subscribe button and hit that little bell so that you receive notifications of when we go live or put up new content. First on the docket today, the South Dakota Attorney General has finally been charged with a crime. That's right, Jason Ravsborg. He is the Attorney General in South Dakota, and for those who do not recall, he hit a man and killed a man about 5 months ago. The investigation took 5 months. Normally, the South Dakota State Patrol would handle the investigation, but since that organization reported directly to the Attorney General, it was outsourced to use accident reconstruction experts from Wyoming and the North Dakota Bureau of Criminal Investigations. This case started to develop back on September 12th of 2020. When the Attorney General was returning from a Republican fundraiser, and he stated that he thought he had hit somebody, and he actually called 911. He actually stated he thought he hit an animal. He returned the next day with his chief of staff, whereupon they found the man by the name of Joseph Bover, who was killed. He had been walking along the side of the highway because his car had broken down. Now, the Attorney General stated that he's been cooperating the entire time with the investigation. There were several irregularities about this case, given the fact that the Attorney General returned some 15 hours later back to the crime scene with his chief of staff, whereupon they found the body of Joseph Bover. He was the man who had been struck by the Attorney General's car and ultimately died along the side of the road. The Attorney General did not give a blood sample that evening, but it was the following day, some 15 hours after the investigation. Now, these particular charges that have brought the Attorney General to court, and this time with a defendant behind his name, are misdemeanor charges of operating a motor vehicle while using a mobile electronic device and veering out of his lane. Pretty straightforward. The Attorney General has stated that when he hit something, he was distracted on his phone. He's also been charged with careless driving, which carries up to 1 year in the county jail. Finally, charges were filed after last week. Many people started to express frustration that it took 5 months to complete the investigation. A lot of people were starting to think that perhaps there were political favors being made and that charges were not going to be filed at all. Mr. Bover's family wanted felony charges filed, but since the prosecution does not have a valid blood result to be able to show that the Attorney General was intoxicated at the time, they're unable to file those charges. We'll continue to follow this case. We'll also be curious to see if the Attorney General believes that he needs to resign his position. Next on the docket, do you recall last week we brought you a story about Derek Chauvin? He's the police officer charged, obviously, in the George Floyd matter, and he's the one primarily charged. The other officers, former officers, Officers Tao, Koenig, and Lane, had their trials severed. Well, there was a newspaper article that went out, and it discussed the fact that early on, Derek Chauvin was prepared to plead guilty and receive a federal sentence of about 10 years. Now, then Attorney General William Barr put a kibosh to that. So the attorneys for the now former police officers have filed a motion asking that the charges be dismissed, specifically saying that there's no room to allow the prosecutors any wiggle room to refile the case in the future. And they ask for a litany of sanctions, including a judicial order to ban whomever leaked the materials from participating in Tao's trial, and a ban on allowing outside lawyers to participate in the case. Naturally, they've also asked for the order banning jurors from serving on a case if they've heard of the leaks. Clearly, this goes directly to the 6th and 14th Amendment of the United States Constitution, and those provisions guarantee criminal defendants the right to an impartial jury. When you read the motions, they basically accuse Minnesota Attorney General Keith Ellison and prosecutor Matthew Frank and Special Assistant Attorney General Neil Catel of various forms of and levels of misconduct under Minnesota case law and the state's rules of professional conduct. In Tao's motion, it states it is impossible to overstate the magnitude of this misconduct or its prejudicial effect on the defendant's constitutional due process rights of a fair trial. If this leak would have happened during the trial, the court could be required to declare a mistrial and to dismiss the charges with prejudice. Koenig's motion more broadly accuses government actors of a wall of prosecutorial misconduct involving both leaks and other matters. It describes nefarious motives of Mr. Ellison for failing to personally participate in a court hearing after stating in an email that he would be personally present at a meeting immediately following the hearing. Mr. Ellison's late decision to absent himself from the hearing suggests he knew about and may have personally been involved in developing the strategy to cheat the defendants out of their right to due process. Mr. Ellison distanced himself and did nothing to intervene or to correct the state's ill-intentioned conduct. So here's what this means. Plea negotiations take place in cases all the time. That's what everybody does. Prosecutors say, hey, I don't know if your client did it. I don't know if he wants a trial or not, but here is an offer. You say, that's ridiculous. My guy didn't do it, but he'll take this, okay? But jurors are never supposed to know of any sort of plea negotiation that's taking place. And the prosecution leaking this information goes directly to a defendant's right to a fair trial by saying, oh, they were going to plead guilty. They would have pled guilty, but, we didn't think it was going to be accepted. That is inappropriate. Whomever leaked those documents to the press, and if they are an attorney, should face sanctions, no doubt. And if it was the Attorney General himself, Mr. Ellison, he is going to have or should have even bigger problems. But what does this really represent? I think this represents that the state is starting to realize their case is not getting better as time goes on. As time goes on, people are obviously still upset about the case of George Floyd, but the evidence that was more than likely is going to be presented from the defense is that George Floyd died of a drug overdose. Yes, things could have been handled differently, but he died because of the drugs that he was on. That's going to be the defense. The defense is going to have experts to testify to that proposition, that theory of the case. I personally believe, and this is my opinion now, that the prosecution is getting concerned. They've had all of these trials severed. Derek Chauvin will go shortly, and then later in the summer, the remaining 3 officers will have their trial. That is not what the prosecution wanted. They want delay, and this is a way for the prosecution to potentially get that delay. I hope this judge, if he can determine who leaked those documents to the press, that this judge crushes them. And if they are an attorney, that attorney be sanctioned. That's just unfair, and it crosses the line. Next on the docket, you have to be a licensed professional to perform surgery. If it's good enough for people, it should be good enough for animals. Well, meet Larry Collin and Frankie Huertas Rivera, and they were arrested last week on felony animal cruelty charges in the death of a pregnant dog. Collin, the owner of a French bulldog named Lila, allegedly paid Huertas Rivera $650 to perform an illegal C-section at his home in Florida. Authorities allege that Huertas Rivera is not a licensed veterinarian and Colin was aware of this fact. Following the surgery, Colin brought the dog to a veterinary office. A doctor at a local clinic reported to the police, according to the affidavit, that the dog was dead upon arrival along with 2 puppies. In the affidavit, police allege Colin told the veterinarian and her staff that the surgery was performed at his house by a friend of a friend that is unlicensed, and they were just simply trying to save some money. The police also have some very damning evidence because Colin's 15-year-old daughter posted a since removed video of Huertas Rivera performing the operation on TikTok. The video allegedly shows the dog in a semi-sedated state, withering in pain as Huertas Rivera attempted to deliver puppies. The vet told police that the pregnant dog and her puppies undoubtedly suffered unjust cruelty and suffering due to unethical medical services performed. Both men were arrested on the animal cruelty charges, and Huertas Rivera was given an additional charge of performing an unlicensed surgery. Now we'll give everyone the presumption of innocence, just like we will for the Attorney General. But when the surgery that no one is licensed to perform is recorded and ultimately put up on TikTok, it would seem like the prosecution is going to have a very good case. As we've said before, don't live stream the crime scene. Next on the docket, another school case. Can you guess what? That's right. This person was an assistant principal. How old was the girl in this particular case? 7 years old. We will give now former assistant principal of the Oak Hills High School, Mr. Matthew Lynn Johnson, 42, the presumption of innocence, because everyone is afforded that here in the United States when an allegation is made. Now the prosecution must prove their case beyond a reasonable doubt. And that presumption remains with them unless and until Mr. Johnson pleads guilty or is found guilty by a jury of his peers. No need to go into the details on this one, as I'm sure you can imagine what they are, which is a good place to take a quick recess. Go to CrimeTalkSearch.com. We're talking about principals working with people's children. Now, maybe this principal had no prior issues, but my guess is there was probably something there. And if somebody had conducted a background check, they may have been able to discover that and maybe prevented a lot of heartache. So go to CrimeTalkSearch.com, sign up for that background subscription service today, where you're going to get a report detailing everything about somebody's social media, phone numbers, emails associated with them, along with criminal history, property records, divorce records, bankruptcy records, and civil judgments. Things that people don't necessarily come right out and tell you, but you may want to know about that if you are going to get involved with them. Usually there's some sort of indicator that if people had just looked close enough, they'd be able to find it. Go to CrimeTalkSearch.com. You'll be happy that you did. Next on the docket, a case has been closed because body remains have been found. The ironic twist of this case is that somebody's already been convicted of the death of the individual of the remains that they just found. Alexis Murphy, her remains were just recently found back in December of last year. And last week, the medical examiner in Richmond, Virginia, confirmed that the remains were positively identified as those of Alexis Murphy. Now, Alexis disappeared back on August 3rd of 2013 after she went to a gas station. Searches have continued throughout the past 7 years. It's been continuous, according to the Nelson County Sheriff, Sheriff David Hill. There's always information that comes in, and they apparently have been checking on leads over the years. What makes this a little different is a gentleman by the name of Randy Taylor, he's 55, is already serving 2 life sentences for Murphy's murder. Investigators charged him years before Murphy's body was found because they felt that they had enough evidence for a conviction. Taylor has appealed his case, and it's been denied at each step, including up to the Virginia Supreme Court. The prosecutors went forward with this case because they had video footage that showed Taylor at the gas station around the time that Murphy was there. Now, a gas station employee saw Murphy and Taylor talking to each other before they both drove away. Inside Taylor's camper, investigators found strands of black hair that appeared to have been forcibly removed, along with a fingernail fragment. DNA testing confirmed the hair and nail were that of Murphy. Under a bush outside of the camper, investigators found a bloody shirt with Murphy's DNA on it and her cell phone, which had been broken by being crushed. Now, Murphy was a senior in high school at the time of her disappearance, and obviously justice has been served, and now at least the family will have the remains to perform a proper burial. Sad case. Sometimes justice just takes a little longer. And finally, our dumb criminal contestant of the week. Please meet Bruce Morway. He's 57. Well, and Mr. Morway was on parole. In fact, he told his parole officer that on February 11th, he was going to go to a job interview. Well, it looks like he may have taken a bit of a detour because he was accused of going and robbing a bank. The police put up a photograph of Mr. Morway, and they weren't looking to find him because his mask wasn't being worn properly. No, it was because he robbed a bank. Fortunately, Mr. Morway's parole officer saw the photograph, recognized him, and guess what? Mr. Morway is now in custody on a $100,000 bond waiting for a trial. Mr. Morway, you are a dumb criminal contestant of the day. I have said this many times before. There's an easy way and there's a hard way. And it seems like most defendants always take the hard way. And there's no such thing as easy money. You have to work for it. And Mr. Morway, thinking that he was going to make some easy money by stealing it from a bank, obviously realized that that didn't quite just work out. And now, over the years that he is going to remain in custody, and perhaps Mr. Morway wants to go back to prison, perhaps he's institutionalized, and this is the easiest way to get back there. We may never know, but if Mr. Morway accepts our mug, we will ask him, what the hell was he thinking? All right, that's all you have for today. Thanks for watching. Please don't forget to follow us on Instagram, Facebook, Twitter, TikTok. Yes, TikTok. And if you'd like to go support the Crime Talk family, you can sign up to be a Patreon member, and you get extra value when you do that. Thanks for watching. Have a great day. We'll see you tomorrow.